अभी आवाज आ रही क्या? हेलो 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 1 2 3 4 आ रही क्या आवाज? नाही नाही फोन मधला तुम हा अच्छा तो हे पाहिजे नाही का? चालू नव्हतं. इकडे इकडे
पंखा कुठे आहे सर?
ते कुठे चालू होतं?
आम्हीच केलेलं आहे.
Discussion on the controversial bill discussing the hijab law. The month of March witnessed a groundbreaking moment in Indian history when the Karnataka High Court delivered the hijab judgment in the case of Reshma versus State of Karnataka, in which the Honorable Court upheld the notification issued by Karnataka government banning wearing of hijab in the educational institutions. The court held that wearing hijab is not a part of essential religious practices in Islam faith and thus cannot be protected under Article 25 of the Constitution and is thus not violative of any fundamental rights enshrined in the Indian Constitution. It was argued before the court that this wearing of hijab is a patriarchal notion and oppressive to Muslim women. But on the other hand, the question of freedom of expression for Muslim women comes into play. Sara Srininger, in her research article, Veiled Women, Hijab, Religion and Cultural Practice, mentions the hijab's history is a complex one, influenced by intersection of religion, culture over time. While some women, no doubt, veil themselves because of pressure put on them by society, others do so by choice for many reasons. Since the judgment was delivered, a lot has been written for and against the same. Today, therefore, we are here to discuss the judgment with various perspectives. Now, I would like to call upon Dr. Sanjay Jain to deliver a welcome speech.
Students, respected principal sir, faculty, professional assembly. Razia Patel Madam, who has joined us online for this important event. My colleagues, my two vice principals, Dr. Deepa Patukar and Dr. Suntur Nair, my other colleagues and students. After 2 years, Center for Public Law, which is a platform to hold different events, different talks on the nuances of public law, is organizing this event offline. And as a faculty coordinator of this, I'm very happy to roll the ball physically about the activities of the center. Because Kaushikar sir has come to meet us after a long time. Very briefly, if I were to introduce him about the center, as well as to new students who have taken admission to the college now, or those of you who might have had now faith memories about the center. Center started its activities in 2010 onwards. And if I were to very briefly tell you some of the landmarks of the center, we organized a very important event, we are doing case one Bharti, which culminated into the publication of a book, which I happened to co-author with my senior colleague, Dr. Suntur Nair. Apart from this event, we have organized a number of conferences, and the most important event which closely allies with today's function is the national conference which we had organized on religious and political aspects of personal laws and freedom of religion. Besides, we also happened to revisit a number of landmark cases, and we also organized events like Const Icon and Const Olympiad to look at constitution objectively. So I am very happy that me and my colleague Mr. Kendra, who look after the center, and the rest of the colleagues who participate in different activities of the center will add different activities. This year there is an important change which has happened to the center. Now we have decided to work together. We have decided to collaborate criminal law center as well as the international law center. So the main reason for the same has been to organize all public law related activities under one platform. So hopefully this intersection of criminal law, international law and constitutional law will help us refurbishing the activities of the center and to give students new perspectives, maybe connected perspectives. Along with the same, we now also emphasize that law is not something which is autonomous. Law has to receive from other social sciences like political science, sociology, psychology, etc. And therefore, it is important to hear from likes of Professor Kaushikar and Razia Patel, who have their own interdisciplinary social science perspective, and this lends us interdisciplinary perspective to look at the things. So, with this, let me welcome Sir formally to the college. Let me also welcome Patel Madam. I will again welcome all the participants. Thank you very much.
Good afternoon, everyone. I would like to introduce the panel for this discussion today. Our first speaker is Dr. Sanjay Jain. Dr. Jain specializes in constitutional and administrative law. He has a total experience of more than 19 years His areas of interest include feminist jurisprudence and gender justice, with special reference to the Indian situation, comparative constitutionalism, sociological jurisprudence, disability rights jurisprudence, human rights of marginalized groups, legal theory, and jurisprudence in international economic law. Our next speaker is Dr. Nitish Navsade. Dr. Navsade is an assistant professor at ILS Law College. He has a specialization in constitutional law, criminal law, administrative law, and jurisprudence. He has a total teaching experience of 16 years, and his areas of interest include jurisprudence, criminal law, constitutional law, media laws, law and social change, etc. Our next speaker for today is Mr. Suhas Palshikar, who is an Indian academic and social and political scientist. He has taught political science at Savitribai Phule Pune University and is the chief editor of studies in Indian politics. He is also the co-director of Lokniti Program of Constitutional Democracy. And our last and final speaker for today is Ms. Razia Patel. Dr. Razia Patel is working since the last 20 years on various academic and field research projects on issues covering various aspects of education of minorities. So without further ado, I would like to call Dr. Nitish Navsade to start off this panel discussion with his views on the legal aspects of the judgment.
A very good afternoon to you all. Honorable Speaker Palshikar sir, Principal of ILS Law College, Dr. Jain, faculty members and dear students. It's really good to see you in such a huge, big number. This is the first program we have after the unlock and review of the college. And now for this first program, to see students in such a big number is definitely quite thrilling. It's a happy moment for all of us. I'll cut short all the introduction and come to the point. I'll be dealing with the judgment which was delivered by the Karnataka High Court. And for that, some facts about the judgment. What are the points of issues which the judgment had? And my opinion regarding the judgment. Dr. Jain will be putting a critical comment on the judgment. And then after, Razia Madam will speak and Principal Sir will speak at the end of the three speakers. So this is how the schedule for the day is. Now this issue came up in Karnataka at the New Year Eve, wherein the pre-university Udupi Degree College, pre-university degree college in Udupi, wherein there was a Muslim women were not allowed in school for the reason that they are not wearing uniform. Now they were wearing hijab, that is headscarf, and then because they were wearing hijab, they were not allowed. That is how the situation started. Wherein some notification came up from in February, notification came up from the government. The notification says that in case of schools, the government school, the government will issue what the uniform is. In case of private school, the management will decide what the uniform is. In case of pre-degree schools, it is a CDC, College Development Committee will decide what the uniform is. And where there is no such decision taken, uniform should be keeping in mind all the things and something that it should not disturb public order. That was the whole part of it. So you should not wear a uniform which should be disturbing public order. Now with this, you know what has happened, that the Muslim woman wanted to attend the classes wearing hijab. The school said that we made a law where we are not allowed to take classes for the reason that you are not in the uniform which is prescribed. And then this doesn't start, the politics came up after this. But the matter went in Karnataka High Court, and Karnataka High Court initially said that so long you don't decide, the rule stands that you can't attend school without wearing hijab. Then the decision comes in. Now in this decision there are few issues which are decided. There are four important issues which were decided in this case, which we raised. The first one is whether wearing hijab, that is headscarf, is a part of essential religious practice in Islamic faith protected under Section 2, Article 25 of the Constitution. Second one, whether the prescription of school uniform is not legally permissible, as being violating of the petitioner's fundamental right inter-allied guaranteed under Article 19(1)(a), that is freedom of expression, and Article 21, that is privacy of the Constitution. Article 21 is interpreted to right to life and liberty as also includes right to privacy. That is how it is. Then whether the government order dated 5/2/2020 is the order which has co-governed, apart from being incompetent, is issued without application of mind and further is manifestly arbitrary and therefore violates Article 14 and 15 of the Constitution. And the last one, whether any case is made out in writ petition number so and so for issuance of writ for initiating disciplinary action against respondent number 6, that is those teachers or the schools, for initiating of writ of quo warranto against respondent number 15 and 16. That is not the much concern for discussion because it's quite an individual issue which comes. The three issues which the court had to discuss about. The first one, whether wearing hijab is an essential religious practice of Islamic faith. Now, first thing, what do you mean by essential religious practice and where does this doctrine come from? The origin of this doctrine has a very interesting history. It happened so when there was a debate going on in the Constituent Assembly, and the debate was on Hindu code. Dr. Ambedkar made a statement. He said that in India, religion touches all the aspects of human life, and therefore, it will be a fallacy on our part to say that all those aspects which the human life which religion touches are religious, and therefore we should limit the jurisdiction of religion to those religious practices which are those things which are. We should limit ourselves only to those things which are essentially religious. Now see this part. So what is it doing? Is actually making a distinction between what is religious and what is secular. And this is important for the reason that when we go to Article 26, we make a say that matters which are secular in nature is management of a religious denomination. If you want to buy a car, at that time you can't say it's a matter of right of religion, you have to pay taxes. So matters which are secular in nature will be covered by, they're not protected by freedom of religion. So will be covered by the secular laws. So he has a point in saying that in India, if you go that what is religious and what is not religious, it is very problematic because you will say everything is religious because every aspect of human life is touched by religion. So we should limit the jurisdiction of religion to only those things which are essentially religious. This was picked up by Supreme Court in Shirulbhat case. The issue was regarding offering of prasad and bhog at a specific time to the deity. They said that whether it is essentially religious, that is what the debate goes in. So the whole debate is about what is secular and what is religious. The problem came up with Allahabad High Court judgment. Allahabad High Court, a case came up that there was an employee of Uttar Pradesh government, and it's a bigamous marriage. The case is of bigamy. It's a bigamous marriage. He said, as per my religion, I need to have a son so that he can perform a last rites, and therefore I should have a right to marry second time. And therefore, if bigamy is made punishable, that goes against the right to religion. Now, where the Supreme Court said, and this is what I will just read one part of the Allahabad High Court said, and we'll see what things happen. Polygamy is not essential part of Hindu religion. Now, here, there's a key shift. The word essential has gone from qualifying the nature of practice, that is whether it is religious or secular, to qualifying the importance. Whether religion, that is, whether something is essentially religious or it is essential to the religion. It is something essential religious practice and something which is essentially religious. They are two different things. Something which is an essential religious practice. Now, what did Supreme Court say? Supreme Court said that something which is an essential religious practice, on that part we cannot interfere. Something which is not an essential religious practice, we can interfere. And therefore, in Saifuddin Sahib's case, they said that the Bohra community head has a right to excommunicate a person because it is part of essential religious practice. And they created Jews food is what amount to essential religious practice. It is something that if you don't practice it, you cease to be a religion. You cease to be a religion. There's a critique which is made there, says that whether a judiciary in a democratic society should actually be a religious code to decide what are the essential religious practices. You're not supposed to go into that domain. And therefore, Sabrimala judgment, which is in review in Supreme Court, this matter is there. Now, the Karnataka High Court actually says whether wearing hijab is an essential religious practice. Now, what is the court did? The court went to what the Quran says, what does Hadith says, whether it is a command in Quran, whether it is a command in Hadith. If it is a command in Quran, then only we can go ahead, and everything goes in, and then further it comes to a point. And I'm not going to take much of your time, but it says that Holy Quran does not mandate wearing hijab for Muslim women. However, it is stated in Surah so and so, we say it only directly because of the absence of prescription of penalty or penance in wearing hijab. Why it is directly? For the reason that there is no punishment. Holy Quran says that you have to wear hijab. Because now we are the domain of this whole part of what religion says. So there is a problem with this argument. The problem with this argument is that we are denying an agency to a woman. She can use it only if the religion allows. She cannot use it if the religion doesn't allow. So woman as an individual is completely not in the picture. We said what is important for religion. And now here the quote says that the Holy Quran does not mandate wearing hijab. So it is a discretion. And therefore, why it is directly? Because it does not prescribe a penalty. So all those things to which Holy Quran prescribe penalty is an essential religious practice. That is what the logic goes in. Now, I'll just come to the concluding paragraph when it says that, as it goes into going to text and everything, that is not much of thing. Your report says that, as stated that the matter that are essential to religious faith and belief have to be adjudged in the evidence borne on a record. Now, in this case, there is absolutely no material placed on record to prima facie show that wearing of hijab is part of essential religious practice in Islam, and that the petitioner has been wearing hijab from the beginning. Now, the problem is that if you could have shown, the petitioners could have shown, as a matter of even affidavit or an evidence, that the girls who have protesting were wearing hijab from the beginning, I think the judgment would have been different. That's what they want to say. They further say, this apart, it can hardly be argued that hijab in matter of attire can be justifiably treated as fundamental Islamic faith. It is not that if the alleged practice of wearing hijab is not adhered to, those not wearing hijab become sinner. It says that if you don't wear hijab, it doesn't matter that you become sinner. Islam loses its glory and it ceases to be a religion. Now see the argument part. It says that if you don't wear hijab, it is not that you become sinner. Islam loses its glory and it ceases to be a religion. That is the reason it is not an essential religious practice. Now in Islam, 5 time namaz is essential. Now if any person doesn't offer 5 time namaz, Islam doesn't lose its glory. Right? So the point of argument is that will Islam lose its glory because any of his follower is not practicing it? Cannot be a parameter of deciding whether it is an essential religious practice. Therefore, the parameter is problematic. Now, a petitioner miserably failed to meet the threshold requirement of pleading and proofing of wearing hijab is an inviolable religious practice in Islam and much less a part of essential religious practice. Now, petitioners have brought some citations, some authorities on which they relied upon. Courts say that this is not an authority we consider to be an authority to be relied upon. Petitioners have cited cases of Madras High Court and Kerala High Court wherein they said that wearing hijab is essential. The court didn't rely on that judgments. But now the petitioner, they say that you have not brought anything to a notice to show that it is essential. Now what is the problem? The problem is this, that your talking comes to understand. Article 25 gives a right to an individual to practice religion. It doesn't give a right to a religion. Article 25 is not right of religion, right to a religion. It is right of religion which is given to individual. Islam will lose its glory if it is not followed. It means that you are talking about religion has right. You said religion has right. That is a problematic proposition. We are not talking about religion, we are talking individual practicing it. Now, the second argument which we got that, if you read Article 25 says that individual has freedom of conscience and freedom to profess practice religion of his own choice. So there are two things. One is freedom of conscience, second is freedom to profess practice religion of his own choice. See, conscience will give a person who is a person like me, who doesn't follow any, who doesn't believe in God, who doesn't believe in afterlife, who doesn't know any religion. He can have this. But still he has a conscience. So that is guaranteed in Article 25. Now, conscience is something which you develop on your own. One argument which was made that forget about whether religion says it or not. I have to wear a hijab as part of my conscience. And therefore I should be allowed. They say that we are not sure that from when you have this conscience. So the court in the judgment said that when we wearing hijab from the beginning. Now it may happen that I may develop a conscience today. I am a non-vegetarian, I may develop a conscience that I should be vegetarian because it is not good that I should eat non-veg food. Now this is something, I'm just talking about non-veg, any to develop something. Now, do you want to go that from where have you developed it? See, the premise of this whole judgment is that in the judgment says that this is something which is developed by students' Islamic force and then some progressive Islamic thing, and this part of this, and they want to create some nonsense in society, therefore they have created it. And that is the reason the court, keeping this in backdrop, says that from where they have developed this conscience of wearing hijab. Now, this is completely a political decision which is taken by. Okay? When has this practice been started? This question comes in because there is an argument made that this is what the students don't want it, somebody is asking them to do it on the basis of religion. And taking this backdrop in mind, the court says that from when have you created this conscience? On so and so date. So this conscience is not something which you have to accept to be a conscience of Article 25. That cannot be a fair logic. Because I'm talking about it's a Muslim woman something, apply to anyone. This cannot be a very legitimate logic. Now the interesting part goes in about uniform, dress and discipline. Now here the judgment itself says, as to school discipline, uniform and power to prescribe same. It starts with the idea of schooling is incomplete without teachers, taught and a dress code. The idea of schooling is incomplete without dress code. Collectively they make a singularity. No reasonable mind can imagine a school without uniform. After all, the concept of school uniform is not a nascent one, and this is something where we always have to go to Vedas. It is not the Mughal or the Britishers brought it here for the first time. It has been since the ancient Gurukul days. This is how this paragraph starts. You know what will be the conclusion. You know what that means. You know where they're heading to, right? This is not how you come to a conclusion first and then you find out citations. That is what has been done. Now, I think the judge is unaware about something called as Nayi Tanzim, what Gandhiji was speaking about. The judge was not aware about all those experimental schools which came up with that we should have different variety of nothing called uniform. I just quote something on uniform which is very interesting. How is uniform part of the point is that prescribed uniform is not in the legislation. And because it's not in the legislation, you can't do so. It is ultra-wide, that is what it said. Now they said that there is a legislation of 1988, and in that legislation of 1988, it says that you can prescribe curriculum. You know what you mean by curriculum? Curriculum?
Yes, curriculum.
Syllabus?
Yes, sir.
Right? Now there is the word curricula employed in section 270 of the Act needs to be broadly construed to include power to prescribe uniform. So, defining a curricula is also said that you can also prescribe uniform. And therefore, the state has power to prescribe uniform, therefore it is no controversy. Now, about uniform, I just want to speak about this part. What they have said. Petitioner contained that classroom should be a place of recognition and reflection of diversity of society, a mirror image of society, socially and ethically, and a deeper analysis ethically. They said on a deeper analysis, this is a hollow rhetoric. So, the classroom should not be a reflection of society. This is hollow rhetoric. It says that petitioners argue that the goal of education is to promote plurality, not promote uniformity or homogeneity, but heterogeneity. And therefore, prescription of student uniform offends the constitutional spirit and ideals. This argument is thoroughly misconceived. So, what is the goal of education? We should not promote plurality. No, don't do that. Okay? It is the whole idea is to promote uniformity and homogeneity. The court has interestingly compared schools with prisons. They said that, and that is what it is. Okay? Qualified public places like schools, courts, war rooms, defense camps, etc. The individual freedom as of necessity is curtailed, constrained, and the discipline and decorum of the function curtailed, constrained with their discipline and decorum. It further speaks about under trials and completely connected prisoners, and they have different rights, and therefore students and those who are not students will have different rights. So, where does this analogy comes in? That is basically a very problematic part. I would like to just bring in what Michael Foucault in his book Discipline and Punishment, what he speaks about. He says that He explores the parallels in the functions of modern institutions like schools, prisons, hospitals, factories, and asylums. He says that the idea of school itself, the idea of schooling with this uniformity, is something to discipline you. Uniforms are believed to be necessary because they teach children acceptance of external authority, that is external to the self and to the family members, without any apparent conflict. Even before they enter the school, children are given the message that schools are places where they are expected to behave themselves. And uniform plays a role of strengthening this message. Once that message is internalized, socialization, which is equivalent to discipline, becomes easier. So the problem is that there are other scholars who says that prescribing uniform is also problematic in school, and therefore, the High Court says that we cannot imagine a school without uniform is not an correct proposition, and they don't cite what authorities are relying upon. It may be a personal view, and personal view cannot be a judgment. Now, apart from this uniform part and this school curriculum part and other part, the major part was that there was this circular which says that you can issue a circular wherein no dress code is prescription such that would afford equality, integrity, and would not disturb the public order. And many schools, they said you should not wear a hijab for the reason that it is disturbing public order. Why? Because others don't like it. Right? They don't like it.
I would now like to call upon Dr. Sanjay Jain to deal with the further legal analysis of the student.
Good afternoon, friends. Professor Pashikar, Vijay Patel Madam, and my colleague, Dr. Nausagri, all faculty members and the students. I think having heard such a powerful speech, neither I have points nor power. And particularly the share was the cherry of the cake. But nevertheless, as a professor, as a teacher, it is our job to reinvent the wheel and try and find out if scopes are broken or if we have to add new scopes. That's what I'm going to do. Now, Dr. Nausagri very cohesively and very lucidly he explained the entire judgment, brought out all the issues, and he also very tersely explained both the arguments and the stand of the court. But as a student of law and particularly as a student of constitutional law and as an ardent supporter of diversity, one question which I want to ask myself and to all of you is, what happens when you ask yourself wrong questions? What happens? Naturally, if you ask yourself wrong questions, you will come out with wrong answers. That's what has happened, unfortunately, in Karnataka High Court, because it asked wrong questions, it came out with wrong answers. I'm also complaining. What wrong questions? So that the wrong answers. The first thing which a judge ought to remember is he has to decide every case point blank. Point blank means you have to decide the case as narrowly as possible. So, did you adopt the right frame and the right lens when the case came before you? Whether you are entitled to adopt the kind of frame and lens you chose to adopt while handing down the judgment. That is the opinion of the question. And in my opinion, because you chose wrong lens and wrong frame, you came out with wrong answers. Now, the simplest question before the court was whether The government circular was ultra virus, a parent act. It was the simplest and easiest issue to be dealt with squarely through the lens of administrative law. But no, we want to play to the gallery. We want to show off our knowledge of public law. We want to quote American scholars. We want to say that no, we will not quote South Africa because South Africa is different, but America is close. My God, what an interesting logic. We are allied to America, but we are not allied to South Africa. Mahatma Gandhi went to South Africa to wipe out racism, and still South Africa is not allied to us. America is our home. God bless the knowledge of the people who demand. No disrespect meant, because I will be unoffended. But the point is, how can you quote Americans and say that South Africa is out of context? The Pillar's judgment, right? That's the Pillar's judgment, they cite that. Now, let me give some punches which I want to have kept to the judges. Firstly, I want to ask them, why did you not quote a single Islamic scholar, Islamic female scholar? When you are writing about the hijab, you are writing about the lived experiences of Muslim women. So why you did not write, why you did not cite a single female Islamic scholar? Is there a drought of female Islamic scholars in this country? Our dear friend Razia Patel Madam is here, one of the brightest Islamic scholars. Why you did not refer to her views? You want to represent the Muslim women, you want to do justice to them, so why don't you speak to their mind when you write your judgment? This is my first question, and I see no answer coming out from the court, because court simply does not have any answer. That is my first point. My second point, how do you reduce this entire issue of wearing hijab to ERP, essential religious practice? Are you allowed to adopt a reductionist path when you write a judgment after Maneka Gandhi's case? Are you not required to do an integrated reading of fundamental rights? Can you read Article 25 in isolation? Can you read Article 25 and 26, divorce, the golden triangle of the Constitution, Article 14, 19 and 21, so nicely articulated by the judges in Minerva Mill case? Again, the answer is clearly judges of the Karnataka High Court has no answer whatsoever. Why they chose to look at this case only from the perspective of APR? Why they did not look at the case from the perspective of dignity, from the perspective of liberty, from the perspective of freedoms? Again, no answer. The next point, when you talk about discrimination, after the Nitisham judgment, which is a path-breaking judgment delivered by DYC Justice Dhananjay Chatterjee, now it is the law of the land under Article 141, and it is binding on all the high courts, including Karnataka High Court. Indirect discrimination now is the part of the Indian jurisprudence on discrimination. So what about the disproportionate impact of the hijab ban on Muslim women? What about the intersectional effect of a woman being Muslim, being part of the minority, and being under even the patriarchy of the Muslim males? So look at this extraordinary sandwiching of the Muslim women. She is sandwiched between the Islam patriarchy, she is sandwiched between the so-called emancipation patriarchy of the neo-right, and basically without representing her, without speaking to her mind, we are giving her the lessons. Okay, we want to emancipate her. Right? But the point is, what about her operation? Do we know the reasons? Do we know the reasons why a particular woman wants to wear the hijab? Why do we link the hijab necessarily with Muslim women? That is my question. Lord Fuller used to say in his lectures, or even in his book on law and morality, he used to caution us. Do we really know the purpose underlying the law? So are we sure, are the Karnataka High Court judges sure Muslim fire the hijab by saying that only Muslim women wear it is to demonize a particular cult, demonize a particular section of society? But what is most interesting is, what about the intersection between Articles 15 and Article 25. Because if Article 25 allows you to preach and practice your religion freely and equally with others, Article 15, I think my last point, I'm tempted. The judgment says that there is a distinction between derivative rights and original fundamental rights. To divert, to deflect the attention from the argument based on proportionality. Because the petitioner argued that even if it is assumed that you want to discipline the classrooms, was ban on hijab the least restrictive means? That was the question posed. They say that proportionality rule is applicable to substantive original fundamental rights, but choosing the apparel of your choice is merely the derivative right, and derivative right do not enjoy the status of fundamental rights, the original fundamental. I don't know from where they got this. In fact, if you read Maneka Gandhi and Aftermath, they are all judgments dealing with penumbral rights. They are all judgments dealing with derivative fundamental rights. Puttu Swami is the epitome of derivative fundamental right to privacy, enjoying equal status with all fundamental rights. In fact, if you read Gorgon, it's merely interpretation. It's not creation of any new right. Court has not invented any way. Court has simply interpreted Article 21 to read into it the different aspects of life. Therefore, friends, unfortunately, I did not get the opportunity to find out any shade, but therefore my presentation is not going to be as stylish as such. But still, I would say that if anybody asked me to make a choice between diversity and uniformity, I would definitely run away with diversity because I am myself the product of diversity. Thank you.
I would like to now call upon Dr. Razia Patel, who will be joining us virtually for more insights.
Hello, can you hear me? Hello.
Yes, ma'am, we can hear.
हेलो मैं हिजाब इशू के जो पूरे सोशल इम्पैक्ट्स है उसके बारे में बात रखूंगी, लेकिन उससे पहले मैं संजय जैन जी की आभारी हूँ कि उन्होंने इस इशू पर आज ये प्रोग्राम रखा है। यहाँ उपस्थित सभी साथी जो है, संजय जी, नीतीश, वर्षा जी और आदरणीय सुहास जी, मैं जो ये इशू रखने वाली हूँ इसका मुझे लगता है कि इंटरप्रिटेशन जो है या पूरा पर्सपेक्टिव जो है इसको देखने का, तो मुझे लगता है कि 2 से 3 पर्सपेक्टिव जो है यहाँ डिस्कस होंगे। सबसे पहली बात जो है कि ये जो हिजाब के लिए मुस्लिम बच्चियों ने PIL दाखिल की थी, उसमें रेशमा, मुस्कान, आयशा, आलिया, शफा ये लड़कियां थी और इन लड़कियों की उम्र है 17 साल और ये लड़कियां कोर्ट गई, टीनेजर लड़कियां, कि हमें हिजाब हमारा धार्मिक अधिकार है और उसको प्रोटेक्ट किया जाना चाहिए और स्कूलों में भी जो है उसको हमें परमिशन मिलनी चाहिए क्योंकि ये इसेंशियल प्रैक्टिसेस है हमारे मजहब में। इस पर जो जजमेंट आया तो उसमें ये बताया गया कि इस्लाम का इसेंशियल पार्ट हिजाब नहीं है। उसका जजमेंट क्या कहता है ये एक बात है और कम्युनिटी क्या सोचती है ये दूसरी बात है। मैं महाराष्ट्र के मुस्लिम परिवार से आती हूँ और हमारे यहाँ हिजाब का कोई चलन नहीं था मुस्लिम परिवारों में, तो हमारे पूरे समाज में न कभी बहुओं ने हिजाब पहना, न बुर्का पहना, न बेटियों ने पहना, दादी ने भी हमारे कभी नहीं पहना। तो वो ये कहती थी कि देखिए आपका आप क्या पहनते हैं वो डिसेंट होना चाहिए। ज़रूरी नहीं कि आप पूरा शरीर लपेट लें किसी कपड़े में। हमारी दादी ये कहती थी। और आपका आचरण, बिहेवियर ऐसा होना चाहिए कि आपको पर्दे की ज़रूरत ना पड़े। और वो ये कहती थी कि आपकी आँखों में पर्दा होना चाहिए। तो हिजाब इसेंशियल प्रैक्टिस होना, इसके बारे में जजमेंट क्या कहता है, ये अलग बात है। समाज में क्या सोच हिजाब के बारे में थी और है, वो हमको देखना चाहिए। कुछ लोगों को ये लगा कि कोर्ट क्यों मजहब के मामले में नाहक दखल दे रहा है, क्या जरूरत थी धर्म के बारे में कोर्ट को बात करने की। लेकिन हमको ये समझना पड़ेगा कि इन लड़कियों ने मांग की थी कोर्ट से कि हमको हिजाब पहनने की परमिशन स्कूलों में मिले। तो ये भी हमको देखना चाहिए कि लड़कियों ने खुद मांग की थी, इसलिए जजमेंट में उस पर बोलना पड़ा कोर्ट को। लेकिन इसमें जो है हमको इसके पॉलिटिक्स ऑफ हिजाब इशू जो है, ये जजमेंट ऐसा है कि जिसको हम पूरी तरह से वेलकम भी नहीं कर सकते और पूरी तरह से उसका विरोध भी नहीं कर सकते, क्योंकि इसमें बहुत सारे एस्पेक्ट्स जुड़े हुए हैं। वो सारे हमको ध्यान में लेने पड़ेंगे। देखिए इसमें जो अलग अलग पीआईएल्स आई उसमें एक थी इसी के साथ जोड़कर, उसमें एक थी कि सबको यूनिफॉर्म पहन के स्कूल आना होगा, ऐसे एजुकेशनल इंस्टीट्यूट्स ने कहा। दूसरे कुछ जो पीआईएल्स आए उसमें ये आया कि कट्टरपंथी इस्लामी संगठन जो है उसमें SIO, CFI, कैंपस फ्रंट ऑफ इंडिया, जमात इस्लामी, हाँ, ये इस्लाम का को आगे ले जाने के लिए इसका जो इनके काम चलता है पूरा, उसके बारे में रिपोर्ट मांगना चाहिए। और दूसरा था कि सऊदी अरेबिया से इनके लिए पैसा आता है। तो कोर्ट ने ये तो नकार दी पीआईएल, लेकिन इन इन लड़कियों की जो थी उस पर तो इसका मतलब ये है कि जिस तरह के इनको जोड़कर, इस पीआईएल को जोड़कर जिस तरह के और दूसरे पीआईएल्स आए, इसका मतलब ये है कि पॉलिटिक्स कितना खतरनाक है। ये सिर्फ हिजाब इशू नहीं है, ये इससे भी ज्यादा बहुत गहरा पॉलिटिक्स है। लेकिन ये भी एक कॉन्स्पिरेसी है कि लोग हिजाब इशू पे बात करते रहे और इन मुद्दों पे कोई चर्चा नहीं हो कि ये पॉलिटिक्स कितना खतरनाक है। और न ये सिर्फ मुस्लिम महिलाओं के और मुस्लिम समाज के लिए बल्कि देश के लिए भी कितना घातक है, ये पॉलिटिक्स हमको इसका समझना पड़ेगा। दूसरा, इसमें इस जजमेंट में जो कहा है कि मुस्लिम महिलाएं हिजाब की बात कर रही है कि ये हमारे मजहब में इसेंशियल प्रैक्टिस है, तो ये नहीं है। ये जो 3 जजेस थे जिसमें एक मुस्लिम महिला भी थी, और इसके बारे में उन्होंने बहुत सारा डिस्कशन किया और आर्टिकल 25 के बारे में भी, फ्रीडम ऑफ कॉन्शियंस क्या है, इस पर भी डिस्कस किया और इस बात को इस जजमेंट में डाला। दूसरा ये जो है कि स्कूल मैनेजमेंट तय करेगी कि क्या यूनिफॉर्म हो, इस बात को इस जजमेंट में माना गया है और वो उनका अधिकार है स्कूल एजुकेशनल इंस्टीट्यूट्स का, ये बात की है। अब यहाँ हम जो बात कर रहे हैं फ्रीडम ऑफ चॉइस की बात कर रहे हैं, तो ये बिल्कुल साफ बात है कि जिन स्कूलों में यूनिफॉर्म तय कर दिया गया है और जिसका कि इंस्टीट्यूट को अधिकार है, एजुकेशनल इंस्टीट्यूट को, कि क्या यूनिफॉर्म होगा, उन्हीं इंस्टीट्यूट्स के बारे में जजमेंट बात कर रहा है। बाकी पब्लिक प्लेसेस जो है वहाँ वो उनका चॉइस जो है मुस्लिम महिलाओं का कि हम बुर्का पहने या नहीं पहने, वो उनका चॉइस है। तो ये भी फर्क ध्यान में लेना चाहिए कि पूरे समाज पर इस तरह से बैन नहीं किया गया है। और स्कूलों में जहाँ यूनिफॉर्म तय है वहाँ की बात की यूनिफॉर्म का नियम आपको पालन करना होगा, ये बात कही गई है। दूसरा इसका एक पहलू जो है वो ये है कि प्रोग्रेसिव फोर्सेस की रिएक्शंस इस पे क्या है। तो वो ऐसा दिखाई देता है कि वो बहुत कंफ्यूज तरीके से इसके बारे में रिएक्शंस प्रोग्रेसिव फोर्सेस की तरफ से आ रहा है। अब देखिए कि मूवमेंट्स जो काम करती है वो ह्यूमन राइट्स के लिए, आजादी के लिए इंसान की काम करती है। तो हमारी आइडियोलॉजी में हम व्यक्ति स्वतंत्रता को कैसे देखेंगे? अगर विमेन्स मूवमेंट ये कहती है, हिजाब को सपोर्ट करती है, तो एक पैट्रियार्कल सिस्टम का जो सिंबल है उसको वो इनडायरेक्टली सपोर्ट कर रही है। ये बहुत ही पेचीदा मामला हो जाता है। तो माइनॉरिटीज को सपोर्ट करने का मतलब क्या है, ये हमको क्लियरली रखना पड़ेगा कि माइनॉरिटी को सपोर्ट करने का मतलब क्या है, रियल इश्यूज या इमोशनल इश्यूज। और इसमें जो है ये पूरा मेरा ये मानना है एज ए मुस्लिम एक्टिविस्ट, मेरा ये मानना है कि ये तो पूरा आंदोलन नॉन इशू के आसपास ही बुना गया है। क्या हिजाब रियल इशू है मुस्लिम समाज का? तो मुस्लिम समाज में जब आप बात करेंगे तो मुस्लिम महिलाएं 4 मुद्दों पर बात करती है। पहला मुद्दा है कि हम अच्छा एजुकेशन चाहते हैं, दूसरा मुद्दा यह है कि हम सिक्योरिटी चाहते हैं, तीसरा मुद्दा यह है कि हम रोजगार चाहते हैं, और फिर चौथा मुद्दा वो कहती है कि हमें कानून कैसे चाहिए। तो हिजाब इशू तो उनके एजेंडा पर नहीं था, तो हिजाब इशू कैसे ऊपर आ गया? ये पूरा जो मैं ये कह रही हूँ कि इस जजमेंट को समझने के लिए हमें बहुत सारे सोशो पॉलिटिकल इश्यूज को देखना पड़ेगा। अब इसमें क्या हो गया कि इसका पोटेंशियल हिजाब इशू का क्या है, ये हिंदुत्ववादी फोर्सेस ने वहां पहचान कर उन्होंने जबकि इन कॉलेजेस में लड़कियां बहुत पहले से हिजाब पहन के आ रही थी, लेकिन उन्होंने ये इशू क्यों निकाला? क्योंकि अलग अलग स्टेट्स में जो इलेक्शंस हो रहे थे उसके लिए इसका फायदा हो सकता था, क्योंकि बहुत दिनों से लड़कियां पहन रही थी, तब मैनेजमेंट ने कुछ नहीं किया। लेकिन कब निकाला ये इशू? तो इलेक्शंस को देखकर ये इशू निकाला गया। ये एक बात। दूसरी बात ये है इसमें कि ये लड़कियां टीनेजर लड़कियां हैं, ये हमारे इस देश की बच्चियां हैं। अगर वो कुछ गलत तरीके से सोच रही है या कोई हट कर रही है तो हम उनके साथ कैसा बर्ताव करेंगे? कर्नाटक गवर्नमेंट ने उनके साथ एनिमी जैसा बर्ताव किया कि उनको गेट पे धूप में रोक दिया, भगा दिया कॉलेज से बहुत गलत तरीके से, एकदम अपमानित करके। तो इन लड़कियों को दुश्मन मानना सरकार का, तो ये हिंदुत्ववादी फोर्सेस ने जिस तरह से इशू को इस्तेमाल किया तो वो बहुत खतरनाक है। क्योंकि देखिए इससे सबसे पहले क्या हुआ, तो मुस्लिम लड़कियों का एजुकेशन छूट गया, क्योंकि बहुत सारी लड़कियां इस हिजाब इशू को लेकर कॉलेज छोड़ना पड़ा उनको, वो एग्जाम्स नहीं दे सकी। और जिस देश में इलिटरेसी रेट हाई हो, जिस देश में जब यूनेस्को ने ये नारा दिया था कि एजुकेशन फॉर ऑल बाय 2020, तब भारत में जो सर्वे किया गया था 1986 में इसका रिपोर्ट आया था कि रिलीजियस कम्युनिटीज में सबसे ज्यादा इलिटरेसी जो है वो मुस्लिम कम्युनिटी में है। और आपको पता है कि एजुकेशन का संबंध विकास से होता है, डेवलपमेंट से होता है। तो एक बड़े समुदाय में उसमें भी औरतों को, जो माइनॉरिटी विद इन माइनॉरिटी है, मार्जिनलाइज्ड है सबसे ज्यादा, उनको आप एजुकेशन से दूर कर रहे हैं। तो ये गवर्नमेंट जिस तरह से हैंडल कर रही है इस इशू को, तो इसका सोशल इम्पैक्ट तो माइनॉरिटी कम्युनिटी जो मार्जिनलाइज्ड है, जो एजुकेशन से दूर है, उन पर होगा, और पूरा इसका देश के विकास पर भी और पॉलिटिक्स पर भी असर होगा। इसमें ये तो जरूर है कि इस तरह से कोर्ट में जाना इस इशू को लेके ये इमेच्योरिटी ही थी, इसको हम नहीं कह सकते। क्योंकि देखिए जो समाज मार्जिनलाइज्ड होता है उसे बहुत वाइजली अपने इश्यूज तय करने पड़ते हैं कि किस मुद्दों पर हमें लड़ना है, किन मुद्दों पर हमें लड़ना है। तो इस तरह के इश्यूज अगर समाज उठाता है, क्योंकि मुझे अब भी लगता है कि हिजाब आंदोलन का इश्यू नहीं हो सकता था और कोर्ट में जाने का इश्यू तो बिल्कुल ही नहीं हो सकता था, क्योंकि ये रिफॉर्मिस्ट मूवमेंट का इश्यू है। तो रिफॉर्मिस्ट मूवमेंट के इश्यू भी जब कोर्ट में ले जाकर ले जाए जाते हैं तो उसका असर समाज और पॉलिटिक्स और सोशियोलॉजी पर तो पड़ता ही है। अब दूसरा ये है कि कोर्ट तय करेगा कि हमारे मजहब में क्या इसेंशियल है और क्या नहीं। अब तक मैं ये समझती थी कि कोर्ट ये तय करेगा कि कॉन्स्टिट्यूशनली क्या इसेंशियल है और क्या नहीं। तो ये तो बहुत क्योंकि हमारे यहाँ तो बहुत सारे मजहब है। अब कोर्ट तय करने लग जाए कि धर्म में क्या है और क्या नहीं, और इस तरह के PIL जब आएंगे उस पर इस तरह के जजमेंट आएंगे, तो मुझे ये एक खतरा नजर आता है, क्योंकि कॉन्स्टिट्यूशन में इसेंशियल क्या है ये मुझे लगता है बहुत जरूरी बात है। दूसरा ये कि इस PIL से ये भी ध्यान में आया कि फंडामेंटलिस्ट फोर्सेस कॉन्स्टिट्यूशन को यूज करने की कोशिश कर रहे हैं। कॉन्स्टिट्यूशन फ्रीडम ऑफ फेथ के बारे में ये कहता है कि कॉन्शियंस का फ्रीडम है, कॉन्शियंस का फ्रीडम है। तो पहला उसको टाइटल जो है तो वो अंडरलाइन करता है कि फ्रीडम ऑफ कॉन्शियंस। तो और फिर वो रिलीजियस फ्रीडम की बात करता है, और रिलीजियस फ्रीडम भी पूरी तरह से नहीं है की बात करता है। लेकिन आज हमको ये दिखाई दे रहा है कि फंडामेंटलिस्ट फोर्सेस कोशिश कर रहे हैं कॉन्स्टिट्यूशन को गलत तरीके से इस्तेमाल करने की। दूसरा ये हुआ कि इसमें मुस्लिम महिलाएं कुछ स्टेट्स में रास्तों पर निकली, हिजाब हमारा अधिकार, हिजाब हमारा अधिकार, इस तरह की बात। तो ये इसका एक दूसरा बहुत बड़ा खतरा है कि मुस्लिम महिलाओं का एक आंदोलन जो पूरी दुनिया में मशहूर हुआ और पूरी दुनिया ने जिसकी तारीफ की, वो शाहीन बाग आंदोलन। और शाहीन बाग आंदोलन में रियल मुद्दे उठाए गए थे, NRCCA के मुद्दे उठाए गए थे, और शाहीन बाग मूवमेंट ने किसी पॉलिटिकल लीडर को अंदर घुसने नहीं दिया था, और इसका दुख भी बहुत सारे पॉलिटिकल लीडर्स को था है। तो क्या हो गया कि एक खतरा, एक चैलेंज शाहीन बाग मूवमेंट के आगे आ गया कि अब तो इमोशनल इशू मुस्लिम महिलाएं लड़ रही है, बड़े मुद्दे से, ब्रॉडर मुद्दे से वो एकदम छोटे आइडेंटिटी के मुद्दे पर आ गई। और ये खतरा बहुत बड़ा है, क्योंकि एग्जिस्टेंस का सवाल, ये सबसे बड़ा सवाल है आज मुस्लिम कम्युनिटी के लिए, और ये इशू पीछे चला जाएगा। और वो हो रहा है क्योंकि शाहीन बाग आंदोलन को इस तरह से थ्रेट इस इशू से बन गई। दूसरा ये जो है इसमें कि एक पॉलिटिकल अवेयरनेस महिलाओं की लीडरशिप बना रही थी एक मजबूत सरकार के खिलाफ, और जिसमें वो कुछ हद तक जीत गई थी। तो इस तरह के आंदोलनों को सेटबैक इस तरह से मिल सकता है। दूसरा ये है कि जब प्रोग्रेसिव फोर्सेस इसमें जो है इसमें जैसे हिंदुत्ववादी शामिल है, मुस्लिम कट्टरतावादी शामिल है, और इसमें बीच में तुरंत जगह बनाने वाली अपनी AIMIM जो है, इनका पूरा पॉलिटिक्स अगर हम देखेंगे तो NRCCA पर या धर्म संसद जब कहती है हर ने 20 लाख मुसलमानों को मारा जाएगा, तब ये लोग उसका उस तरह से इशू नहीं करते हैं। लेकिन हिजाब के इशू पर ये सभी इकट्ठे हो गए हैं, हिंदू फंडामेंटलिस्ट और मुस्लिम फंडामेंटलिस्ट। तो इसमें जब अब ये सबसे बड़ा सवाल ये है कि प्रोग्रेसिव फोर्सेस इसको कैसे देखे, इस जजमेंट को कैसे देखे, इस इश्यू को कैसे देखे। तो मुझे ये दिखाई देता है कि जब महिला संगठनों के अलग अलग तरह से जो स्टेटमेंट्स आए, उसमें एक स्टेटमेंट ये था कि जो कर्नाटक हाई कोर्ट का जजमेंट है उस पर सुप्रीम कोर्ट स्टे लगाए, और हिजाब उनका चॉइस है, हिजाब उनको पहनने दिया जाए। इसके 2-3 असर होते हैं। मेजॉरिटी कम्युनिटी ये देखती है कि आप उनके गलत जिद को भी सपोर्ट कर रहे हैं, तो इससे एक रिएक्शन बनता है मेजॉरिटी कम्युनिटी के बीच कि ये तो गलत, उनको तो ये दिखाई दे रहा है कि ये तो गलत तरीके से पूरा इशू चलाया गया। तो इसलिए इनका तो शाह बानो के वक्त इन्होंने ऐसे ही किया था, फिर अभी भी ये ऐसे कर रहे हैं। तो इस तरह का एक ये बनता है। दूसरा ये होता है कि इनडायरेक्टली पीएफआई, सीएफआई जैसे फंडामेंटलिस्ट और एआईएमआई एमआईएम जैसे पार्टी को इनडायरेक्टली ये सपोर्ट होता है। और ये सपोर्ट कैसे होता है, जैसे देखिए कि एआईएमआईएम ने जो पोस्टर्स लगाए बीड में, उसमें एक पोस्टर ये था, दो पोस्टर का मैं जिक्र करूंगी। एक था पहले हिजाब फिर किताब, और दूसरा था हर कीमती सामान पर्दे में रखा जाता है। तो इसका महिला आंदोलन कैसे, किस तरह से सपोर्ट कर सकते हैं, मेरी समझ में नहीं आता। तो इस इश्यू को किस तरह से लड़ा जाना चाहिए ये वो तय नहीं कर पाए। और वो इसलिए नहीं तय कर पाए कि मुस्लिम इश्यूज जो है, मुस्लिम समाज के जो सवाल है उसके बारे में हमारा अंडरस्टैंडिंग क्या है। और हमारा अंडरस्टैंडिंग आज चैलेंज हो रहा है कि सेक्युलरिज्म के बारे में आपका अंडरस्टैंडिंग क्या है, तो डेमोक्रेसी के बारे में आपका अंडरस्टैंडिंग क्या है। तो ये जो है कि जिस तरह से प्रोग्रेसिव फोर्सेस पूरी इसमें कंफ्यूज नजर आती है, तो वो अगर देखा जाए, देखिए इसमें 2-3 बार ये इशू सामने आया है। जब भारतीय मुस्लिम महिला आंदोलन बार बार ये बात कर रहा था कि आवर स्क्रिप्चर्स आर नॉन निगोशिएबल, और हम जैसे जो लोग हैं वो ये कह रहे थे कि कॉन्स्टिट्यूशन ऑफ इंडिया इज नॉन निगोशिएबल एंड स्क्रिप्चर्स और रिलीजन जो है वो मैटर ऑफ फेथ है। तो डेमोक्रेसी में आप नॉन निगोशिएबल किसको करेंगे, कैसे करेंगे। तो देखिए ना कि इंटरप्रिटेशंस तो कितनी आ सकती है, और ये कोर्ट में इस इशू पर रिलीजन को इंटरप्रेट करना, ये बात जो है जो मुल्ला मौलवी करेंगे वो तो कोर्ट कर रहा है, ये बात तो हो गई। लेकिन हजारों इंटरप्रिटेशंस एक ही मजहब के हो सकते हैं, आप कैसे तय करेंगे कि ये है कि नहीं है। तो मुझे ये लगता है कि ये कंफ्यूजन इसलिए है कि महिला आंदोलन भी, और ये मुझे ये बहुत तीव्रता से अभी महसूस हुआ इस इशू के बाद कि किस तरह के कंफ्यूजन प्रोग्रेसिव मूवमेंट में है मुस्लिम इश्यूज के बारे में, जो मुस्लिम समाज के लिए भी खतरनाक हो सकते हैं, और पूरा हमारे जो आंदोलन है ह्यूमन राइट्स के उसके लिए भी खतरनाक हो सकते हैं। दूसरा मुझे इसमें यह दिखाई दिया कि हिंदू महिला है तो उसको पूरी तरह से कॉन्स्टिट्यूशनल राइट्स चाहिए, और मुस्लिम महिला है तो बिचारी को दे दो ना रिलीजियस फ्रेमवर्क में जो अधिकार मांग रही है। एब्सोल्यूट राइट्स जो है वो नॉन मुस्लिम महिलाओं को मिल जाए, ये हम डिमांड करते हैं। और मुस्लिम महिला के लिए हम डिमांड करते हैं कि वो पैरेलल शरिया कोर्ट चलाए, क्योंकि कुछ मुस्लिम महिला एनजीओ भारतीय मुस्लिम महिला आंदोलन जैसे पैरेलल कोर्ट्स चला रहे थे, शरीयत कोर्ट्स। उसके बाद वो काजी ट्रेन कर रहे थे, ये ज्ञान प्रबोधिनी में जैसे पुरोहित ट्रेन किए जाते हैं उसी तरह से। तो ये जो खतरा है कि हमको लगता था पहले कि मुस्लिम कट्टरपंथी ही ये करेंगे, तो वो तो महिला एनजीओ शरीयत कोर्ट्स चला रही थी, महिला एनजीओ काजी ट्रेन कर रही थी, और महिला आंदोलन उनको सपोर्ट कर रहा था। और जब इसका जो परिणाम हम बोल रहे थे वो ही हुआ, जो ट्रिपल तलाक का कानून आया वो क्रिमिनलाइज करके आया। तो हमको हमारे अंडरस्टैंडिंग क्या है मुस्लिम समाज के इश्यूज के बारे में, वो हमको डीपली सोच कर तय करना पड़ेगा। दूसरा मुझे ये लगता है इसमें कि इसके लिए हमको क्या करना होगा। तो देखिए इसका और एक खतरा पहले मैं बता दूं यहाँ। दूसरा ये कि इसमें क्या हो गया है कि वो मुस्लिम लड़की के पीछे जिस तरह से हिंदू युवक ये अकेली लड़की के पीछे 50 आ रहे थे और गले में सैफ्रॉन स्कार्फ डाल के, तो ये जो है ये गुंडागर्दी दम के नाम पर ये यूथ को इस्तेमाल किया जाना जो है वो बड़े पैमाने पर होगा। और जैसे गोरक्षक जो है, गोरक्षकों का हिंसाचार हम देख रहे हैं पिछले कुछ सालों में, तो ये इस तरह से परमिशन उसको खुली छूट मिल जाना, ये एक इसमें खतरा दिखाई दे रहा है। तो दूसरा मुझे ये लगता है कि इस इश्यू को रिफॉर्म रिफॉर्मिस्ट मूवमेंट का एक इशू करके देखा जाना चाहिए। लेकिन दूसरा मुझे ये भी लगता है कि एक अंडरस्टैंडिंग मुस्लिम इश्यूज पे हमको बढ़ाने पड़ेंगे और रियल इश्यूज जो है मुस्लिम समाज के, उन पर हमको इस नजरिए से बात करनी पड़ेगी, ये सारे जजमेंट्स को भी देखते हुए। दूसरा मुझे ये लगता है कि जैसे ILS लॉ कॉलेज जैसा कॉलेज है, इसमें मुझे उम्मीद है, अब बाकी लोगों से उम्मीद खत्म होती जा रही है धीरे धीरे सभी जगह। तो मुझे ये लगता है कि इस इशू पर हमारे यहाँ जो हमारे स्टूडेंट्स है, कॉलेज है, इनका एक बहुत अहम रोल होना चाहिए। मुझे ये भी दिखाई दे रहा है कि PILs हिंदू फंडामेंटलिस्ट दायर कर रहे हैं, मुस्लिम फंडामेंटलिस्ट दायर कर रहे हैं, लेकिन प्रोग्रेसिव फोर्सेस के PILs इसमें न के बराबर है। तो मुझे लगता है कि ये जो बात है, दूसरा वो इशू जो करेंगे ना, वो कॉमन सिविल कोड का करेंगे। हमको पहले ही बहुत तैयार रहना पड़ेगा कि, और साठे साहब जो थे, सत्यरंजन साठे साहब ने तो एक तब पहला ड्राफ्ट और अकेला ड्राफ्ट उनका तब के ILS लॉ कॉलेज का ही हमको अवेलेबल है अभी। इस पर कभी प्रोग्रेसिव फोर्सेस में इस तरह की चर्चा ही नहीं हुई कि किस तरह का होगा। और कॉन्स्टिट्यूशन यूनिफॉर्म सिविल कोड कहता है, ये लोग कॉमन सिविल कोड कहते हैं, ये बात को भी हमको समझना पड़ेगा। तो इसलिए अभी बहुत बड़ा खतरा है कि अगला इशू वो उन्होंने डिस्कशन शुरू कर दिया है कि कॉमन सिविल कोड का आएगा। वो हमने तो तलाक का बैन करवा दिया, हमने तो अभी ये हिजाब इशू को ऐसे हैंडल कर दिया। तो अब हमको लगता है कि हमको आगे के खतरे भांप कर, और देखिए अब क्या बचा है, तो थोड़ा बहुत जुडिशियल सिस्टम से इंसाफ मिल सकता है, ये थोड़ी उम्मीद, थोड़ी, अब वो भी बहुत ज्यादा नहीं बची है। तो इसके लिए हम क्या कर सकते हैं, ये हमको अगला कदम सोचना पड़ेगा। और उसमें मुझे लगता है कि ILS से मैं उम्मीद करती हूँ, ILS लॉ कॉलेज से, कि इन इश्यूज पे हमको एक नजरिया बनाना पड़ेगा, जिसकी चर्चा चलानी पड़ेगी और जो इम्पोर्टेंट तरीके से चर्चा के बीच आए। इस तरह का कोई कदम हमको उठाना पड़ेगा। बहुत धन्यवाद मुझे यहाँ बुलाया।
Other friends from the ILS Law College and students. To begin with, I must thank the organizers of this event, the Center for Public Law at the college, for having me here and also having me here physically. As I was telling Dr. Navsari earlier, after 2 years, I was inclined to say no to this invitation if it were online. So thank you for having me here. We already have had a discussion of, or a critique of the Karnataka High Court ruling in this particular case. I will therefore not go into the legalities, nor can I do that with any justification. But I will point out to you that jurisprudence can help only in a given social context. Jurisprudence, and therefore High Court rulings or Supreme Court rulings for that matter, can't and don't exist in a vacuum. They don't even emerge in a vacuum. They emerge in a context and they operate in a context. And therefore the context of this particular controversy on which the Karnataka High Court has found it fit to finally pronounce whether a particular practice is essential religious practice or not, etc. That context actually is probably the most critical one. In the sense, that context was exemplified by the previous speaker, Dr. Razia Patel, when she pointed out the dilemma and pointed out also that at one place there was this banner asking or exhorting, "Pehle hijab, baad mein kitab." Now, this sentiment among a given community is probably the quintessential response of both what happened before the ruling and because of the ruling. Because the ruling is of this particular time, what you are actually having as a fruit of that, as an outcome of that, is more orthodoxy, more anti-gender viewpoint. That is what you are getting out of it. And therefore, this ruling as well as the controversy need to be seen in this context of what was happening, what was expected, and what is likely to happen now. The Karnataka government simply issued a circular. In other words, it sought to regulate the practice of wearing of hijab in certain types of educational institutions of Karnataka. But even before that, it must be noted that some institutions on their own mandated what girls should be doing and should not be doing. When there was a protest against that, other organizations chipped in, saying that if you are wearing a hijab, then we shall wear our religious symbols on our shirt sleeves or on our foreheads. And ironically, as it were to happen, by the time the Karnataka High Court ruling came, social media also had this particular image of a Hindu person wearing a tilak and a army fatigue. And it was said that in some countries somewhere else, not in India, a special permission was granted to the Hindu soldier to wear the tilak on his forehead. So we pride on that, while we at the same time uphold the Karnataka High Court ruling saying, "Oh, what a great ruling," because it is a learned ruling after all. And not just one judge, but three judges together means lot of wisdom. So it's a three-judge ruling. So we uphold that ruling, and at the same time we uphold this, what was alluded earlier to, as reasonable accommodation. If you are a democracy, then you don't go by strict rules only, but you negotiate the demands of different communities, and you negotiate those demands with also what is called as the law. Then if you find that a reasonable accommodation is possible, you give certain concessions. And this is not unheard of even in India, of giving of such concessions, in order to strike a balance between the uniform majesty of law on the one hand and the sentiments and expectations of a community and set of people on the other hand. We are not French, for example, because in 2016, in response to a terrorist attack by supposedly Islamic State terrorists, some French city governments mandated that if you are going on a beach, you must wear a bikini. See what was happening, and New York Times did a very interesting story where there was a photograph from 1917 when women were penalized because they were wearing a bikini, and then 2016, exactly 100 years down the line, women were being penalized because they were not wearing a bikini. What was the reason? The reason given was that not wearing a bikini and wearing a burkini instead is dangerous to women. So we are so interested in the welfare of women that we keep mandating what they should do and what they should not do. In the hijab controversy, similarly, we forgot the fundamental point, the right to education, and simply started quibbling on the scope of right to freedom of religion. The net result, therefore, was the Karnataka High Court ruling. And while I agree about the critique that Dr. Nausagre and Dr. Jain have presented of the Karnataka High Court ruling, I wonder whether every such public issue can be sorted out by the court. Should we rely on the court for sorting out every such public issue? Because this was a public issue. And that public issue needed to be sorted out only through public negotiation and public accommodation. Instead, what happened was that Karnataka government took a very steadfast stand, as a result of which accommodation became impossible, as a result of which some persons went to the court, and then you have the court ruling on this matter. Now this court ruling might be used elsewhere in the country to similarly restrict the movement of Muslim women who choose to wear a hijab, because it would then become a precedent unless turned down and changed, reversed by the Supreme Court of India. And the Supreme Court of India will take its own time. It has already said, don't raise passions. We will consider the case whenever the case comes to us in the future. So it will take a long time to settle down. It is this context which makes the entire question of hijab extremely complicated. What was being said, or what is being said, as Dr. Razia Patel was also pointing out, this is a difficult issue because we don't know whether in the first place it is essential religious practice to Islam. But let us consign this idea of essential religious practice for once and all, because that practice, which is practiced by a community in a given context, becomes essential to their routine lives. Therefore, going to scriptures and finding out whether a particular practice is essential or not is probably not very good law or not very good judicial interpretation. But secondly, what is even more interesting is that this issue comes up only in the context of one particular community, and one after the other, similar such issues get raised continuously. Suppose a person from one community marries a person from another community, we get worked up and we say that it is love jihad. So there is a sentiment of hurt, and that sentiment of hurt is 1 century old sentiment. Almost for 100 years, this sentiment is being cultivated continuously, that a majority community is being hurt because of the pampering and because of the doings of the minority community. But in the hijab controversy, there was no such question of hurt, because it didn't hurt either the sentiments of the majority community or the opportunities of the majority community. And therefore, we need to look at the broader picture. The broader picture is the lessons that you learn from this particular controversy. And these lessons that I am listing out are not at all judicial lessons. These are straight away socio-political lessons that emerge from this controversy. The first lesson then is that if you want to be recognized as a citizen of this national community called India, then you must behave as expected by the votaries of the majority community. That's the first lesson. If you need to be recognized, and this is not only about the minority community, whoever you are, if you want to be recognized as a member of this national community, citizenship in the larger sense, not only in technical or legal sense, if you want to be recognized as a citizen, as a rightful person belonging to this national community, then there is a precondition, the rider. The rider or the precondition is you must behave according to the expectations, and these expectations are dynamic, they are fluid, they will be defined from time to time. But you must fulfill those expectations of those who claim to talk on behalf of the majority. Remember, it's not a question between the majority and the minority, because the majority as such doesn't come into the picture. It is those who claim that we represent the majority, they come into the picture and they tell you what to do and what not to do. their conditions need to be fulfilled. Only then your membership will be recognized. That's first. Following from that, the second lesson, which was commented upon earlier already in the context of the ruling, is the question of uniformity. It's not about uniform. Uniform is a fig leaf behind which the real problem is being hidden, and that real problem is the craving for uniformity. What do we mean when we say that we are Indians? The answer given by this particular controversy is that if and only if we have a completely uniform way of life for all our members, then only we are a nation. So uniformity is seen as a prerequisite of being a nation. The uniform controversy in Karnataka is thus only a representative of this craving for uniformity. This craving for uniformity represents or expresses itself not just through this question of school uniform, and also increasingly colleges also want uniforms, by the way. Jain sir, you can also innovate. Increasingly, colleges, management colleges particularly, are very keen on having uniforms. And this idea that students must wear uniform doesn't stop there, because then it translates into teachers also should have uniforms. But that is only about schools and colleges. The real point is uniformity in terms of the language we speak, and therefore the insistence on Hindi as the national language, which it is not the national language, but there is an insistence. The trouble then is, however, a vast majority of people in this country do not subscribe to any single religious book. And therefore efforts are afoot over last 100 years to make one scripture as the religious scripture of that majority. Recently, thus, Karnataka and Gujarat have started thinking over making Bhagavad Gita compulsory in school education for oral education. But at the same time, if you look at the intellectual history of India's various languages for the last 100 years, you will notice how gradually we are veering towards a position where it would be argued that though Bhagavad Gita is not the religious scripture of the Hindus, it is the religious scripture of the majority. That will be argued upon very soon. So language, religious scripture is the second one. But similarly then, we also increasingly move in the direction of a uniform eating habit, set of eating habits. It's coming slowly. It's coming with silent steps, but it is coming that there should be a uniformity in the food habits. If I'm not mistaken, only yesterday some scientific institution, nutrition society or something, has decided to bring out an advisory on good food habits. It is known as good food, I guess. You can check from yesterday's newspapers. So food habit, which are good and bad, are being slowly mandated in the name of science first, but subsequently probably in the name of religion also. Many states, and Madhya Pradesh is one among them, refuse to serve eggs in the midday meal scheme for children, which means that it is already being done as to what children in school should eat or not eat. And poor children, they don't have any alternative but to eat whatever is given, because they come from economically disadvantaged sections of the society backgrounds. Through this, I can assure you that within next 2 decades, India would have moved in the direction also of national food. And that national food would be something which we should not deviate from. So all of us must be doing that. The word which was mentioned earlier in the critique of the Karnataka High Court ruling soon will become extinct. It will become out of fashion. and that term is diversity. In fact, only this week or last week perhaps, in a Marathi newspaper, in a column written by a representative of this thinking, it was argued that Hindu culture is singular, there is no diversity in Hindu culture, which then therefore means that from northeast down to south, from northwest down to east, there is only one single culture, and if there is only one single culture, then good riddance diversity. Diversity is gone. These are the larger lessons that emerge from the controversy. So the controversy over the veil is actually unveiling something new to us, something new to India, and that something new is this question as to what does it mean to be an Indian citizen. Is it only about Muslims? That's the final question. Apparently, we may be tempted to think that after all, if I am not a Muslim, I need not worry because it is a Muslim question. This idea of reducing everything to Muslims or to minorities is deeply problematic for two reasons. First, it means that we segregate first Muslims and non-Muslims and leave the Muslims to attend to their problems. So the Muslim problem doesn't become our problem nationally, it becomes their problem. That's one problem or one difficulty. But more importantly, if what I have said has any element of truth and possibility in it, then what happens to Muslims today will happen to many other sections of the society tomorrow. Because this wave of uniformity doesn't stop only at Muslims. It doesn't stop only at minorities. It creates a false majority by steamrolling and homogenizing the majority society. The majority in this society, the majority of India, have their different deities, their different rituals, their different cultural practices, their different sects, sampradayas. Now, if that is to be turned into one single culture and one single national community, then it would mean that gradually the turn of other communities is bound to come. And therefore, we need to think of this as our problem both for moral philosophical reasons as well as very pragmatic reasons. And if we don't do that, then today some Muslim girls might have been kept out of schools. Tomorrow, many of us will be kept out of our own ideas of culture, lifestyle, and well-being. And that is why this veil controversy should be taken into its totality rather than only in its fragment, which is a legal fragment which the Karnataka High Court clumsily tried to handle. Thank you very much.
Thank you so much, sir. We are now going to have a short question-answer round. So there is a mic which is being circulated. Whoever wants to ask a question to any of the panelists can raise their hands.
This question should be primarily to Mr. Nausagre and also to the other panelists. There is one point we discussed as to if courts should go into the essential practices of a religion issue. Now, this is a case, I think, in the 70s or 80s, Kerala. There is a sect in Christianity called the Jehovah's Witnesses, about 1 crore all over the world. And these people do not bow down to any god, any country. They don't sing anthems of any nation. So, in the school assembly, these kids were not singing the school assembly, nor the national anthem. Case went to court. All the courts in Kerala, even the Kerala High Court, said that they have to be punished. Either they have to sing the anthem or they have to leave school. The case goes to the Supreme Court. Supreme Court goes into this one basic aspect about essential practices of that particular religion. And there is a uniformity there. Every Jehovah's Witnesses person all over the world does not sing the national anthem of whichever country he is in. The Supreme Court Court gave a judgment that these people are not disturbing the assembly. They are standing in attention. All they are not doing is they are not singing the national anthem, which is not anti-national. So now, I at one level fail to understand how would the courts come to some kind of a judgment. I think Mr. Panchika or Dr. Jain said that leave this to the public. I mean, do we even know what is going to happen if we leave it to the public? Majoritarianism will bulldoze everything whatsoever. Courts at least give us some semblance of sense. We can at least have a meeting like this. If we give it to the people, we would not be able to have a meeting like even calling a meeting like this. We would be bulldozed. So all we need to do is have a court giving out judgments, possibly try and bring out the checks and balances kind of thing. How we do it, I'm not very sure. I'll give one small thing again, Karnataka, I think this was Mr. Michael Saldana. What had happened was in the jungles of Mysore, policemen got news that there was a raid party going on. The policemen raid the thing and they find judges of the Karnataka High Court and various courts, police officers, litigants, criminals that is, and a few businessmen having a wild party. And police press gets to know about it, it is slashed everywhere. And the simplest thing that the courts do is Indian Express is called up for contempt of court because judge ki badnami ho gayi. Why? Because the judge was found there in possibly state of undress with a female drinking alcohol having a grape night. It was Justice Michael Saldana who, in his wisdom, cancelled that thing. If he give it to the courts again, the courts would have punished the person who is bringing it up. He specifically said that we cannot have the judgment. So instead of blaming the courts, blaming would be a very, very strong word. We need to have methods and ways of means to try and bring in checks and balances. One of the most important things, the way I think primary would be getting this thing about contempt of court. You know, judges cannot be pulled up even if they are wrong. Like what happened with the Mr. Gogoi thing. Girl accuses him of sexual harassment. The Supreme Court appoints a committee, it said he was not guilty. Now, things like these need to be addressed because, like it or not, no one is perfect. So, all we do is try and bring down this imperfection to as low as possible. Zero will still be an impossibility. I would want your opinion on this.
Okay, before we start with the opinion, I think all those who have a lecture are requested to quietly leave the premises and not disturb the session. We'll take more questions and we'll answer the questions together.
Hello. So my question was, is in a diverse country like India, is uniform civil code feasible to apply, and what would be its consequences, good as well as bad? Thank you.
Good afternoon, everybody. Dr. Panchika, I am a great fan of yours and love your Indian Express articles. So actually I have come here because, so my question is simple, like you said it is not only about Muslims, very surely I can see it is, all these people are going to become very anti-women. So as a woman, I'm absolutely concerned that, women are going to be the next target. So I want anyone of you to throw some light on, what issues I feel, whether it's educationally or the social, economic, political forces in this country are doing to women. And it's not only Muslim, it is even Hindu women, I think. You all are under, major issues here. My question.
Do we have any more questions?
So, ma'am brought up a point that minority are being suppressed in situation. So, in this case, do we consider a minority being not so progressed? And if we consider them to be not so progressed, then it would be also the opinion that mostly males dominate the opinion if they're not progressed. So, are they projecting their opinion on the female and they are saying those out loud? So, the question is basically who gets to follow the beliefs they are. So, when we see kids from second standard very good or something, those kids do not have a belief in their own. They are being taught to do so.
and their parents make them do so. So, who gets the choice to believe their opinion and who does not? And when do we think that the person becomes rational to have their opinions being projected to society, and when do they not get to do so? So, do you think a 17-year-old is having a rational decision, or do you think, like, is there an age limit to have your opinions being projected to society?
So basically, दोनों तरफ when I was listening to what the panelists were saying, दोनों तरफ on the first side there were there were military extremists who were portraying this thing as their way, whereas we were also seeing on the petitioner side that it is an essential part of Islam, right? And my question is why hijab can be presented as a choice for women, and how do we tackle the extremism that is also in Islam, that specifically Wahhabism? So how do we tackle that?
I think we'll answer these questions and then we'll take up more questions.
Yes. So we'll take this question. Someone is taking some time.
Yeah.
Okay, let me respond quickly to what Melinda said about Jihad in this case. In this case, the facts are correct that students from Jihad in this community, at the time of national anthem used to rise, but they never used to sing national anthem, and that is how they were expelled from the school. And the matter went to Supreme Court. Now, Supreme Court said in this case that freedom of speech and expression, fundamental rights, freedom of speech and expression could be read negatively. So, freedom of speech and expression includes freedom of silence, and therefore they have a right of silence. That is how the judgment goes. The problem with it here is about Supreme Court or the Allahabad High Court judgment, wherein they mistaken Dr. Ambedkar's code and they went into the whole thing that what are essential religious practice. And then they started deciding, depending upon the scriptures of various religion, what are essential, what are not essential, and they kept on going hereby. That is the whole problem, that what is essential religion, what Dr. Ambedkar said, you want to make a distinction between this is something which is essential religion on which basically anybody claim that he has a right in a religion. And the other thing is, for example, law of inheritance or law of partnership. This maybe your religion may be governing, but anyway it's a secular matters, and therefore these are not essential religious nature. That is what he made a citation of that part. Now, court has mistaken that part, the whole court has mistaken, and they consider what is essential religion to be essential religious practice. Now, this matter is before Supreme Court in the ratification of the Sabrimala, that should Supreme Court go into defining every religion's essential religious practices. Now, while defining it, sometimes you get a judgment of your favor, sometimes you may not get a judgment of your favor. That is not the point here. And therefore, what Dr. Jain said that if you start the question with the wrong, if you start the discussion with the wrong question, you are bound to have the wrong answer. Because then you say that what Quran says, what Quran doesn't say. Now the point is that, for example, Quran, Bhagavad Gita, or Ved, who are you to interpret it? And what is the manner in which you interpret it? Because the problems of interpretation is also available. There the problem starts. Nobody wants to take away the right of the court in deciding things. The point is that the court also have a limitation of there are certain orders that they cannot go into defining what a religion, what a religious practice is essential. That was the point which is made, which is because Supreme Court could argue in Sabrimala ratification. This is one part. I think then comes the other part of contempt of court thing. We can talk it sometime later on whether we should have or we should not have, what is the extent of having contempt of court, whether truth should be a defense to it, and this is one part. I think the other questions are more, I think, exclusive to that.
The problem with answering questions is that one needs to start giving another lecture. So, to avoid that, I would make only a few observations in response to the questions that have been raised. One issue that was raised was can courts be expected to work as protectors of diversity and therefore kind of bulwark against majoritarianism? By nature, by definition, judiciary is always seen historically and at least in theory as a mechanism against majoritarianism even of an ordinary kind, and therefore one can always keep hoping and there is nothing wrong in expecting such hopeful things from the judiciary. The question on uniform civil code as against diversity, I would dump the question simply for the reason that in this institution here itself, a lot of work has already been historically made on the draft for the uniform civil code, which will not in any way encroach upon the practices of different communities, not different religions. And therefore, there are ways and ways of adopting uniform civil code without actually bulldozing the diversity of different communities. The more complicated two issues that have come up and they are interrelated is women's agency. Do women have agency? And whether the girls who are the petitioners in this particular case are doing it on their own or under pressure. And a related question to that was, and that is absolutely correct, the related question was the Wahhabi influence among the Indian Muslim communities. Both are absolutely well taken questions and we need to carefully therefore trade on this. That Wahhabi thing takes me back to the question of essential religious practice and to your territory, that is to say the territory of law and jurisprudence. I think there are 2 points that need to be made. One is, even within Indian jurisprudence as it exists today, there are different takes on what or how to understand essential religious practice. I am not sure, but was it Vijayendra Gadkar who started this practice of reading essential practices into the scriptures of a given community? That practice needs to be given up entirely because that is a wrong practice. A, because we don't know which is the religious scriptures or scripture, and secondly, we don't know how to interpret that. Religion, like any other social phenomena, is a dynamic thing. You can't say that Islam means 1, 2, 3, 4, 5 things. If you do that, then you are actually falling into the trap of the extremists, because that is exactly what the fundamentalists from different religions, whether they are Christian fundamentalists or Muslim fundamentalists, they do precisely this thing. They say that my religion means these 5 things. Whereas all great men and women have always looked upon religion simply as a peg to have on their moral and philosophical understanding of society, but essentially keeping the right of making a decision to the individual. So it is the individual who would decide what my religion is. If I understand right, that is the spirit in which Dr. Ambedkar actually set out to write to the his. So this is something very slippery and the Supreme Court should actually give it up. But coming back to the point that I was making, yes, there is precisely the point. There is Wahhabi influence, there is Saudi influence. How do you counter that? The question is, do you counter that by pushing that community into a corner or trying to negotiate with them? That is the question. And my argument would always be in favor of the latter rather than pushing a community. If you call a community as a villain and then you tell also the same community that now you should behave like this because otherwise there would be extremism amongst you, I don't think there would be any social negotiation possible. And that is where our differences or differences between these 2 sets of thinkings might lie. But as I said earlier, no further lecture, so I will stop here. Thank you.
wants to make a point regarding this.
सिर्फ एक छोटा मुद्दा ऐड करना चाहती हूँ, क्योंकि पर्सनल लॉज जो है उसका मुद्दा जो है वो आइडेंटिटी का मुद्दा बन गया है, और वो आइडेंटिटी का मुद्दा मर्दों के पॉलिटिक्स का मुद्दा बन गया है, क्योंकि पर्सनल लॉज में सबसे ज्यादा सफर करती है महिलाएं, लेकिन वो मर्दों के पॉलिटिक्स में आइडेंटिटी का मुद्दा है. तो फेमिनिस्ट मूवमेंट जो है, महिला विमेंस मूवमेंट जो है, भारत में उन्होंने एक मुद्दा उठाया था कि हम कॉमन सिविल कोड, यूनिफॉर्म सिविल कोड इसके चक्कर में नहीं पड़ना चाहते, हम जेंडर जस्ट लॉ चाहते हैं कि जो भारत के हर धर्म की, क्योंकि जो कानून एग्जिस्टेंस में है वो सभी कानून पूरी तरह से न्याय दे पाते हैं महिलाओं को, ऐसा नहीं है, ना सिर्फ मुस्लिम। पर्सनल लॉज जो है उनका तो सवाल है ही, लेकिन और भी दूसरे जो कानून है उनकी समीक्षा करके एक जेंडर जस्टिस लॉ की बात करनी चाहिए जिसमें भारत की सभी महिलाएं आएंगी। एक ही धर्म की महिलाओं का मुद्दा नहीं होगा वो, तो इसलिए एक कंसेप्ट ये है कि जेंडर जस्टिस लॉ के बारे में मांग करके उसके बारे में एक पर्सपेक्टिव बनाने की कोशिश की जाए।
Good evening, everyone. Thank you for a very enriching discussion. My question is that we have talked significantly about essential religious practices. So, do you think this judgment can open a can of, like a Pandora's box now, because there are so many religions in the country and every religion has different practices? So, do you see this judgment opening a larger discussion about other religions as well as to what is essential and what is non-essential to religion?
Good evening, sir. Although we have discussed about uniform civil code, but I want to take a question regarding that only. Article 44 is like a basic structure of our constitution. Although I don't agree with the concept of uniformity in society, but we have accepted the notion of unity in diversity. In this regard, how can we navigate through this situation in this current scenario in India? And if you want to fulfill the Article 44, because at last it is a basic structure part of the constitution.
This doesn't directly concern this debate, but the question of giving human rights. This was, I think, this is now a case pending in the Kerala High Court. Inheritance for Christian women. Why does the church does not accept women as inheritors of property? Now, this is a question. If you look at religion very narrowly, women cannot be given property of the father or of their ancestors, let us say. Now, do you allow this religion to continue this practice, which I would say is barbaric, or would you want the courts to interfere and stop this practice and bring Christianity, or at least this small part of Christianity, within the framework of what the Indian Constitution says? So we have a catch-20, and we cannot cherry pick. Like with Muslims, we allow them to have their religious practice, and in Christian, we say, no, this is anti-women, so the Indian government law will apply, and Christian women will be given rights of inheritance. We would not be able to have a great meet. How do we make sense out of this whole thing?
Good afternoon. I just wanted to ask that a girl reached the court that she wants to wear hijab as an essential practice and she is not allowed. So she requested the court to intervene. And afterwards, she was not able to prove that hijab is essential practice of Islam. So if she is not able to prove that in the court of law, and on what basis all of the scholars and everybody is trying to say that she should be allowed to wear hijab just because she is not minority?
Very good afternoon to all the respected dignitaries on the dais. My question is directed to everyone on the panel, since because we have such a diverse panel here present today, I would like to get the inputs of every person from their perspectives on this question. So, Suhas sir, while you were making your presentation, you made a very powerful submission where you said jurisprudence emerges and operates in a context. So, keeping that in view, do you think that it is time for us to read down or scrap altogether the doctrine of essential religious practices for something which is more relevant to the contemporary idea of professing faith and conscience? If yes, what in your opinion would be a workable solution? Because let's not ignore the fact that there are a lot of evils which are committed in the name of the religion which cannot escape the king of law. Thank you. Very good afternoon to all the panelists and panelists present here. My question is, how do we decide who has the authority to decide on essential religious practices? Like, for the matter of Islam,
I believe there are 4 sources of Islamic law, which is the Quran, the Hadith, the Qiyas, and the Ijma, the scholarly. I believe same would be in other religions also, and for someone to be a religious authority, as for the alims, which is a male Islamic scholar in the Islamic religion, and as for the alimas, who are female Islamic scholars in the Islamic religion, and so on and so forth for other religions. For someone to be a religious authority, there are years and years of research and study that they go through for them to be called an authority on that particular religion. Now, how do we say a judge or a learned judge or a learned legal scholar who has studied just a few books about a particular religion gets the authority to decide on the essentiality of matter? So, on this basis, I want to ask you, should courts be barred from commenting, quote unquote, commenting on the quote unquote essentiality of religious practices in different religions? That's
I think the panelists can answer the question, and this was the last question for today.
I think I'm extremely happy for your questions. The debate has been very interactive, and as Sir says, it should not be another lecture. But responding to maybe 1 or 2 questions, I will just address. My first response, and I'd like to respond to Razia Patel's point. I think it was a case was, first of all, strategically it was mistaken to have taken this matter to the court, because there was quite likelihood that it would have been detained. Having said so, from the side of court also, I think it was a missed opportunity. Court would have had a wonderful discourse on right to exit. Court would have begged this case on the end of right to exit. Okay, wearing hijab may be counterproductive, maybe disadvantage, but who should decide? Let the women themselves decide, and let them empower. Let's educate them. Right? Let them take decision based on their own choice. So that would not have been as imposing as it used to be when you read the judgment. So I think, and secondly, to beg hijab totally to the Muslim women was also very wrong. Now, the second very interesting question, should we pick religions? I mean, he was asking about the inheritance in Kerala case pending regarding the equal right to inheritance of Christian women. And if we have to give it to Christian women, then why not to also deal with Muslims? My simple answer is, India is a deeply divided society. And when you use the constitution as an instrument of social change, it doesn't work equally with everybody, right? It has to work taking into account the context, as Sal said. So each community has to be given its own time. And I think 75 years is not such a long time when you look at a particular community. And therefore to say that everybody can decide everything in the same time, with same pace, and with same maturity, I think it's wrong. If Christians are ready to listen, what should give judgment or what may cut the question? This in Kerala now, this moment, they say that there are women who are ready to wait. So let's give the moment of ready to wait to get the chance. Right? So therefore, instead of saying that okay, we are picking religions, and if we treat one religion one way, we have to treat other religion another way. Equality does not mean uniformity. Equality means equality. Equality means equity. Equality means inclusion. Equality means empowerment. Okay, I think rest of the questions can be taken by the panelists.
Well, again and again, the question is regarding essential religious practice and the living around it. To answer your question, this Karnataka case has not opened the Madras box, it has opened a long back. And now, before Supreme Court again want to reconsider it. So let us wait till that. But few more judgment will come. Well, let us take this part of Kerala incidents about inheritance of women. If you read Article 25 is, if you speak about your right to religion given to individual, it is subject to public order, health, morality, and other part of the Constitution. Therefore, what prevail over individuals' right to religion, practice, profess, and promote religion is fundamental right chapter, other part of the Constitution. So I cannot say that my religion compels me to practice untouchability, therefore I am going to practice untouchability. Article 17 prohibits me from doing so. And therefore, this is how 25 is defined. Supreme Court further went up to the point, and this essential religious practice point has been come to jurisprudentially at one point, about evolving the doctrine of constitutional morality. They say that is the Shabrimala itself. Now, is it constitutionally moral to do so? And therefore, dignity, equality, and liberty, this trinity of the whole Indian jurisprudence of constitution, on which they build up this whole Ambedkar's idea of constitutional morality in the world. And now, even if something could have been an essential religious practice, but is it constitutionally moral? And if it is not constitutionally moral, we are bound to the Constitution of India, not to religion's text, or not to religion. That is how the argument goes in. But the point is that evolving such type of hypothesis of essential religious practice is problematic for the reason what has been said, that who will define it? The participants said who will define it. You need to have scholarship in the religion. Our Rajendra Gadkari started this part and he integrated everything into the Vedic scholarship, into that judgment, that how it is Hinduism defining who is a Hindu part comes in. That he brings that part. But this is how problematic it would be. So I think the jurisprudence which has come up in India is the jurisprudence of constitutional morality, which would be used to counter this argument of essential religious practice. Now coming to one question that the girls went to Kannada High Court that wearing hijab is an essential religious practice, and the court said, no, why are we discussing about it? It is not that simple. That was one of the arguments. The other argument was part of conscience. The second argument was reasonable accommodation. And the third one was this circular itself is ultra-vires. It doesn't have legality to it. And if you have listened to us, we have said that where do you have the power to dictate uniform? It is in interpreting the word for us curriculum. That is problematic. That is why we are criticizing the judgment. And therefore, this is a major issue at Mr. That what Justice Sanjay Jain spoke about. That you don't have power, you have given it. Second, there was a scope of reasonable accommodation, you didn't allow to do so. And we started with, we can think of a school without a uniform. That was your prejudice, and from where it also operated in school, speak anywhere. And therefore, this judgment is problematic. It is not that because the court said, no, why are you arguing about it? We are saying that judgment is jurisprudentially wrong. That is how the panel to say.
एक कमेंट ऐड करना चाहती हूँ.
Last point we make that let us speak. Razia ma'am speak.
हाँ, एक ही कमेंट ऐड करना चाहती हूँ. मेरे दिमाग में एक सवाल है. वो सवाल ये है कि अगर कोर्ट ये कह देता कि हिजाब इसेंशियल प्रैक्टिस है इस्लाम की, तो हम क्या करते? सवाल ये है ना कि ये तय करके, क्योंकि देखिए रिलीजन के दो हिस्से होते हैं. एक होता है इटर्नल वैल्यूज, दूसरा होता है इंस्टीट्यूशंस. और इंस्टीट्यूशंस का कैरेक्टर तो पैट्रियर्कल ही होता है. तो मेरे दिमाग में ये सवाल है कि इस तरह का कौन इंटरप्रेट करेगा और क्या उसका पूरा इंस्टीट्यूशन होगा. क्योंकि देखिए रिलीजियस इसमें देवबंद और ये इधर उधर फतवे लेने के लिए लोग जाते हैं, लेकिन जरूरी नहीं है कि उनका फतवा माना ही जाए. तो लोग तय करते हैं क्या मानना है क्या नहीं मानना है. तो इंटरप्रिटेशन का जो हिस्सा है तो छोड़ दीजिए, क्योंकि मौलाना देते हैं इंटरप्रिटेशन, देते हैं फतवा, लेकिन बहुत बार नहीं भी मानते हैं लोग. तो ये सवाल मुझे लगता है इस तरह से कि अगर कह दिया जाए कि पैट्रियर्कल जो सिस्टम है वो इसेंशियल प्रैक्टिस तो होगी ही, क्योंकि हर मजहब का रूप जो है उसका एक इंस्टीट्यूशनल पार्ट जो है वो पैट्रियर्कल है. तो अगर इसेंशियल पार्ट बोल दिया जाए उसको तो और कोर्ट बोल दे तो क्या होगा?
Okay, thank you so much. Dr. Sanjay Jain, respected principal and additional charge, ILS Law College. Dr. Paushikar and Ms. Razia Patel, esteemed panelists for today. Dr. Nitesh Navsawale, assistant professor, ILS Law College, and another panelist. Vice Principal Dr. Deepa Patkar and Dr. Santosh Jaigal, my colleagues at ILS Law College and dear students, I take this opportunity to extend my heartfelt gratitude to all the panelists for taking up this issue, initiating this discussion and urging us to think. I thank all the teaching and non-teaching staff for their constant support. Mr. Madhukar Toga, Mr. Mistry, and Ms. India for the technical support, and most importantly, our students for taking this opportunity to attend today's session. I hope from today onwards, you all will think, and as Dr. Nitish Nuksagar and Dr. Sanjay Jain sir pointed out, that the idea of start questioning the idea of oneness and start recognizing diversity in India. Thank you so much.